Welcome to this video, and today I'm going to be sharing a few insights into litigation. Now, no one really wants to get involved in litigation, but sometimes it happens between companies. Sometimes it might be between a customer and a supplier. The supplier's providing goods to the customer doesn't pay for some reason, maybe the goods aren't up to the standard that the customer's hoping for. And so therefore, there's a dispute. And often the parties might go to their lawyers and say, well, on the customer's part, the customer might say, well, they don't want to pay for the goods. And on the supplier's part, the supplier just says that they want payment for the goods. And so the lawyers will often write to one another and quote case law and quote facts and try to persuade the other side that the other side is in the wrong and that the other side should actually agree with what's being proposed by one side or the other. So, in essence, there's three things that I'd really like to share with you in terms of litigation. And at a very, very high level, there are three things that often people talk about, and then they're quite surprised at what the lawyers say to them about these three things. So the first thing is that I like to call it winner takes all. And what that means is that essentially the winner in litigation will get their costs paid, their legal costs, by the loser in general. So what this means is that for a winner, they can actually get not only compensation but their costs paid, but for the loser they might get three bills. They might get compensation that they have to pay the winner, they might have the legal costs of the winner that they have to foot the bill for, and also the loser might have to foot the bill for their own legal costs, so three bills. So before going into litigation, people need to understand that although if they win, they get a lot of their costs paid, not all of them, but a lot of them paid, whereas a loser can actually end up with a huge bill. So therefore, litigation needs to be entered into quite cautiously. The second thing I think that is quite surprising when I talk with clients is this concept of disclosure. In essence, when there's a litigation, each party has to disclose documents, emails, correspondence, etc., both externally and internally to the other side, so that essentially there's a full picture of what happened around the dispute. Now, there are some things which don't need to be disclosed, such as legal advice, etc., but in general there's this disclosure exercise, so that when the judge comes to adjudicate on who's right and who's wrong, the fact is that the judge will be in possession of all the correspondence around the matter, and so therefore should have a pretty good picture of what has happened. The third point is that you often find that there's this word called without prejudice, which is often stated by one party to the other party, and essentially what that means in general is that during litigation one party might put an offer to the other party, but the party making the offer doesn't want that offer to be held against it, such that by making the offer, the other party receiving the offer says, well, you must have been in the wrong, because otherwise you wouldn't have made an offer to settle. So therefore, one party can make an offer, but can make a without prejudice offer, which essentially means that that offer won't be held against it later on. Now, there are various nuances around without prejudice offers, but that's the general principle of without prejudice. So, in summary, number one, what I like to call winner takes all. So a winner normally gets most of its costs paid by the loser, so therefore some caution needs to be exercised when going into litigation. Number two is disclosure. So that means that a party has to disclose documents to the other side, so therefore a party might be slightly concerned about that if it knows it has incriminating evidence that could be used against it, and which it might have to disclose to the other side. And number 3 is without prejudice, and that's all to do with making offers which essentially are not meant to be held against you if you make that offer to settle. So I hope that quick run through has helped you a little bit with understanding more about litigation. Obviously it's a lot more complicated than that, but this gives you a gist, it gives you a feel for what those kind of terms mean. And if you have any queries, then please do email me at jimmy@coachinglaw.com. I hope you can see and feel how excited we are about sharing this information about the legal world with you. We're really interested in what questions you might have for us, and so please do email in and we'll respond quickly to your email. Also, if you have any friends, family or businesses where you think the information on this site might be useful for them, then please do share a link to this free content with your friends, family or businesses so that they can benefit too.